John, I want to start with you. What are you looking for in this Justice Department filing, especially since they asked for 40 pages instead of the 20 they were initially granted? It seems like they have something they want to say.
Well, they made it very clear in the motion to the court requesting the additional space that they felt that they had to address the facts that were not properly laid out in the Trump brief, and the law was not properly laid out. And that certainly is true. And so I can understand why they wanted to go after that. I think what they're going to do is put together a very compelling knockdown of some of the cooperation claims that Trump has made by laying out the scenario as it unfolded. And they can do that now with what they could do only under seal for the special master, for the magistrate judge to get the probable cause. They can now do that in lay language and broadly explain why they had to do what they did. And I think the other thing they want to do is knock down the idea that there is an executive privilege here. There is none under the law. It is a fantasy that Trump doesn't seem to understand, that you can't invoke executive privilege against the executive. And that's what he's trying to do here. And Biden has the final word. Trump is no longer president, and they're going to straighten the law out on that.
Whatever it is, it'll be the most we have heard from DOJ since the search itself. Everything that's been released to this point was actually in advance of the search warrant, the affidavit, things that were prepared before. This is a chance now to respond to what's been in public. Phil, there's also this government review process going on right now of the documents that were seized at Mar-a-Lago, one by the FBI that began in May and the other by the Office of the Director of National Intelligence. What are each of these reviews trying to determine, and how could they affect the investigation?
I think there's two pieces of this. I can talk to you about what they're determining, but I think this is a political process. It's not a national security or intelligence process. The FBI is looking at a legal case. That case involves whether somebody had information that was inappropriate to keep. That's a legal question, obviously. The CIA and the Director of National Intelligence, the National Security Agency, are looking at a separate question. Not the law, but what information was held at Mar-a-Lago, how sensitive was that information, and how costly would it be for that information to be revealed? To cut to the chase, I think most of that, to be blunt, is irrelevant. I think the important question is what the former president will do with this, and I think both sides win. The Democrats are going to say after the damage assessment that the information the former president held was hugely sensitive and would have been hugely costly had it been revealed. And the Republicans are going to say there's no evidence that any of this was ever revealed. So therefore, why were you in such a rush to go to Mar-a-Lago? I think this ends up, John, as a political story, not a security story.
You mean just the review of it all?
Yes.
Understood. So, John, now that the former president has added an attorney to his legal team, Christopher Kise, do you expect, or what do you expect to see different in their legal strategy? Perhaps more coherent?
I don't know. He's got a reputation as a good lawyer. He's won some big cases in front of the U.S. Supreme Court and the Florida court. What I couldn't find in looking at his background, that he had any understanding of national security law, and it's kind of an esoteric body of law. I don't see him having any sort of Washington-based experience to understand how the intelligence community operates. So I think that he's going to be learning at first and trying to understand it. I don't know if he understands the concept of executive privilege, which is pretty, it's not really comprehensible to most non-Washington lawyers at first. Then they get it. So I think he's got a learning curve, but I think he's a good lawyer.
Phil, I want to ask you finally about, we heard President Biden tonight speaking out strongly against the attempts of violence against the FBI, which we've already seen, one that was almost deadly, and then the comments that have been made about the FBI. And then on top of that, Senator Lindsey Graham's comments that he thinks there'll be violence in the streets if the former president is indicted. First off, what do you think of Lindsey Graham's comments, and how do you think the FBI is reacting behind the scenes?
Let me hesitate a moment, John. My mom is not with us. She would have washed my mouth out with soap. Lindsey Graham is a good guy. He's a funny guy in the green room. I've spent a lot of time with him. He's an engaging guy. But in my world of extremism, let me cut to the chase. People who want to commit an act of violence don't need to be told to commit an act of violence. They need to be told that their anger is validated and that their anger is appropriate. Senator Graham validated people who believe that violence against the system is appropriate. He's going to apologize. He's going to say that nobody ever told anybody, including him, to commit an act of violence. But I followed extremism for 35 years. An 18-year-old, a 20-year-old, a 30-year-old is going to look to him and say, he just told me that it's appropriate to be angry about Mar-a-Lago and I will do something. My mom would say, wash his mouth out with soap. He's not a bad man. That's a horrible mistake. Never do it again.
Thank you, Phil Mudd, to you and your mom. John Dean, as always, thanks to you as well.